So good afternoon to all of you. I hope I am audible to everybody. So today we are getting into the subject legal. What is legal? What is the importance of legality in maritime? What is shipping law? All these things we'll be covering, especially how important is general principle of law, how law is acting as a tool for social control, and how did this general principle evolve? What is the sources of this law? Where did they get this law from? And what are the type of courts? So before we get into the subject, I would like to share something. What is a law? What is the role of law or legality in maritime? Basically, law is something which is derived when a cultured society was formed. During the ancient days, if you look back to our history, there were barbaric cultures where humans, animals, and all the living creatures were treated very unlawfully or unethically. The modern day human, when he evolved, his brain, his knowledge, his culture, his activities to his fellow person group, and the brotherhood or the livelihood between the two human beings shared that they have equal opportunity to live in this world. So now, when they come into an agreement, whenever they do equality, when they say there is an equal posture in a country or a society, who is the person who comes into picture? The courts, the judicial system. Correct? Now, if you look at the how a country works, India is a democratic country. We all have our voice. When the democratic country doesn't listen to what it's abide as the land of law, what happens? All of us have a right to go to courts. Correct? That's a judicial system who acts as a person who cross checks everything if things are in order or not. So when you feel there is not something wrong between you and your business, or if there is any problem that you're facing in a democratic country, you go to the court and say, "Oh, see, this is something which I'm unfairly happening to me." So the court goes as per the law. Correct? So when this is a common process of law, and law has its own rulings, it decides what is right, what is wrong. How is legal aspect of maritime? How does this work? If you look into this maritime business, it's basically shipping. So a vessel is being moved from one place to other place. I'm sure all of you know how does this operate. Now, when a vessel is being moved from one place to other place, it is not just a movement of that vessel. It is the movement of living beings or humans in that vessel. Point one. Point two, the cargo or the materials in that vessel. Is it that only the movement happening in that ship? It is crossing lot of countries, the boundaries. So whenever it crosses the countries and boundaries, the lines which they have prescribed, they are supposed to abide a law of that particular nation or that particular country, whichever is strong. So when you see 70% of the world is covered with the water, so sea. So basically, shipping is the major and cheapest way of communicating, transporting stuff from one place to other place. So overall, in this subject, we will learn what is the legal aspects of shipping and how complicated it is when you don't follow it, and what are the laws which are applicable in shipping law. Okay, I hope you got an idea of what we are looking at this one. So now let's see what we will understand. So here, importantly, if you look at your examination point of view, there would be questions asking, say, importance of general principle of law, explain how law is acting as a tool for social control. There can be evolution of general principle. How did that evolve? You can even discuss about sources of law and list the type of courts, what kind of courts are there, and how does it work. Okay, so now let's see what is the importance of understanding the law and general principle of law. So as I explained earlier, law is an instrument of social control. For example, there is a declaration of lockdown law, correct? Now that's kind of a law which is being passed, so we are all being a social animals, we are supposed to follow it, correct? So all these are affecting or controlling the social environment is something called law. So if you see, man by its nature like to be free and work without any restrictions. He doesn't want anybody to control him because he thinks he is his own boss. But it doesn't work in a society that a man can be freely what he is when he's in his house. But when he is involving a third party, when he is doing a business, when he is doing a transportation, it is not just he is involved. He is involved. The transportation involves not many categories. A ship owner, the staffs, the charterer who hires the ship. So there are many third parties who get involved when you do a business. So for all of them to abide, there should be a law. Now, coming back to law and its principles, how did it evolve or growth? So Aristotle, I'm sure all most of you know, he wrote that man is when perfected, is the best of animals. But when separated from law and justice, he is just the worst of all. I hope this is very clear. Example, what Aristotle said is that when there is somebody who is monitoring you, you become the perfect person. That is the nature of man. When there is nobody to do a doctrine of checks, the man will act on his own free will and it can do a lot of damage to other people. Correct? So that is why to bring a proper doctrine of checks, to bring a proper checks and order, law is being implemented. Now, what kind of laws are there? There are civil laws. There are civil laws which is predominantly seen for us because in shipping, natural law and civil law come in hand in glove. Now, when we discuss about civil law, it is considered as divine during Middle Ages, where religion is developed along with those historical Middle Age time. Saint Thomas Aquinas wrote that every law framed by a man bears the character of law exactly to that extent to which it is derived from the law of nature. But if in any point it is conflict with nature, it ceases to be a law and mere perception of law. So, law of nature has to go with mankind and dedicated by God Himself. Of course, the superior is obligation to any other. It is binding overall globe in all countries and at all times. So basically what they're trying to explain is no human laws are of any validity if contrary to this. When you are doing anything which is going to harm the humans or the nature, then it is of no law. Such a, so we cannot validate such law is what they say. There is another famous Hudson says that there's a phrase what Hudson says: general principle of law is recognized by civilized nations. As I explained earlier, when the human nature tried to improve his social life, he become more civilized. So when the civilization grew, they wanted a society which is acting where their citizens are acting in a civilized manner. And who is the person who checks if the people are acting in a civilized manner? The court of justice, the courts, the justice system. So that is where it makes that law and the legal prospects of law is very important in a civilized society or a nation. So whenever there is a business which is happening, an agreement or a contract is being done because there should be a civilized dealing between that business. Now let's see what this interpretation of statutes. So enacted laws, the modern acts and rules are drafted by legal experts and expected that language used will leave little room for interpretation or construction. Interpretation is art of finding out the true sense of any form of words, and construction is drawing out of conclusions. Beyond the direct expression of the text, the conventional way of interpreting and constructing a statute is to seek intention of legislature. I hope the interpretation of statutes is clear here. Now, the intention of legislature assemblage is two aspects. One thing is it carries the concept of meaning, what the words mean. Basically, now if somebody gives a legal agreement saying, now this particular person is being my tenant, or I am giving my land for lease for 12 months, means the word, the meaning of the word written in that agreement is the end of it. There cannot be more of interpretations for it. Now, if somebody is giving a vessel for a charterer, say to use, when if there is a time contract, now a ship owner is giving a charterer a contract ship for him to use it on a time contract, say for 10 months. So when, if an agreement, if it is written that the ship owner has given the charterer the ship for 10 months, now the charterer cannot exceed the usage of ships more than 10 months because it is very clearly written. So the words and the meanings is very clear. That is why it is that is the meaning of it. Point two is that it conveys the concept of purpose and object, or the reason and spirit pervading the thought of through the statute. So it explains what is the purpose of doing it. Now, if somebody is taking a contract of a shipping company, say for example, they want to charter a ship from Singapore to India or some reasons. Now he will have to express his purpose of doing it. He should express the seaworthiness of the ship. The ship owner has to share the ship is in a very good condition to operate from here to this distance. So all this and what purpose is the charter using it? Now tomorrow he will say that he is transporting a perishable item from say Singapore to maybe India, or maybe from Sydney to India. Now the purpose of his transportation, if he is mentioning that it is goods, he is transporting the say his logistics and cargo materials, and he cannot do illegal activities. He cannot transport ammunitions in it. He cannot transport guns in it. So that purpose has to be mentioned very clearly in that. Okay, so there cannot be extra definition for what we mentioned in the legal aspect. So it is very clear and derived. So other principles are that statutes must be read as whole. Statutes to be considered to be more effective and workable. Because if the meaning is plain, effect must be given to the irrespective consequences. Next, the guiding rules are that language and statute should be read as it is. There cannot be extra meaning for what we write. Avoiding addition of words. We cannot add up more extra words because it is a very clear statement which is understood. Avoiding rejection of words, departure from the rule, and rule of illiterate construction. The natural and grammatical meaning, explanation of rule, exact meaning preferred, technical words in technical sense, regard to subject and object, general rule of heads and case, regard to consequences, hardship, inconvenience, injustice, absurdity, and abnormality. So all this guiding are the guiding rules when we come into an agreement or when we make a law. Okay, hope this is clear. So now let's see how law is acting as a tool for social control. Now, as I said, law is something which does this doctrine of checks. It comes and gives you the justice. So law is an instrument of social control. Now, human nature being what it is, everyone wants to have its own way to think and to express. Maybe when you are going in a cargo ship or in your vessel, there can be so many countries citizens in this working with you. So one may be from Africa, one can be from Singapore, one can be from India, one can be from Pakistan. So all will have their own thoughts and their own ways of expressing. So tomorrow there should be somebody saying that no, I don't want to be or do this particular job because it is against me. We cannot. So when if somebody comes and say that okay, no, I cannot do this job when he is so a law is something where he'll accept. So that is where they give you an offer letter. So that is also kind of a law. So when you get an official offer letter from a company that says what is your roles and responsibilities and you agree doing it, correct? That's an agreement between you and the employer. Similarly, it's an instrument of a social control. So this is how it controls in social. Now, how did this evolve? Philosophical perspective that law occupied a prominent place in writings of Plato and Aristotle. If we go back to history, you can see that the evolution of growth of law is very evident. So man was being trying to become perfect as much as possible. So out of animals, they say that human being is a social being, is a social animal. So he has to be perfect because there is a law and justice which makes him separate. And he is worst of all if that law and justice is not in the land. So if you see go back to our the Roman culture also, you can see that the natural law and the related concepts and civil law was predominantly seen during those days. During Middle Ages also, law began to be considered as a result of divine relationship. So according to not nominative, what ought to be, the law is general body of rules commanding general obedience, enforced by sovereign political authority. Being command, law must be obeyed regardless of fact whether it is in conformity with morality or however ethical bad it might be. Thus, it was Austin who distinguished law from morality and theology and restricted the term of positive law of sovereignty. Those days, people were confused between religious followings and law and morality. So Austin was one of them who could give an idea of positive law of sovereignty by distinguishing between all these three. Now let's see what is the history of general principles. The study of law is largely the study of history. Its history is one of repeated efforts to impose legal constraints by various modes of law applied by its state. Even in law of war, often those efforts which failed to produce a treaty, the treaties that were produced were often less than fully effective. So, while laying down the principle of law, judicial decisions are to be referred for better understanding. Now we have international law, which is part of our law and must be administered by the Court of Justice to appropriate jurisdiction. For this purpose, where there is no treaty and no controlling executive or legislative act or judicial decision, resort must be had to customs of usage civilized nations. So now If you take an example that from international waters, if there is a ship which is coming to Chennai without a permission, the Chennai High Court has the authority to arrest the vessel. So the Chennai court, under POXA, Carriage of Goods Act, Carriage of Goods Act by C, 1925, the High Court of that particular jurisdiction can arrest the vessel if the vessel is coming into the country or the border without any proper documents. So all this is the current situation of law. But where did this evolve from? This were all evolved from the ancient history and general principles made us create all such laws and judiciary system. So why do we need to study general principles? So law is a tool in kit of a practicing lawyer. Is an intellectual equipment. So now when there is a disagreement between your chatterer or when there is a collision, say for example, one ship is colliding the other ship. Now both the parties will try to blame each other, right? Both the ship owners or ship parties will say that it is his fault, it is not my fault. Correct. So so the law will help finding the fault and give suitable solution for whoever is needed. That is why the legal aspect and knowing the maritime law is very important. Now, sources of law. Law is made for men. Who is making the law? Men. So we make our own law. This is because the term law is used in many senses, depending upon the context in which the term is used. So whether it is scientific law, social law, or moral law, the term law is widest sense means rule of action. Okay, so rule of action is something which we cannot ignore. It is going to be the supreme of everything. The minute a law is being passed, that is becoming the supreme. So people usually say that it's our Bible. No, it's our supreme power. Law is supreme. Nothing is beyond law. Similarly, Blackstone says that law in its most general and comprehensive sense signifies a rule of action and is applied indiscriminately to all kinds of action. Rational, irrational, even Mark B in his book says elements of law says that law is a term which is used in a variety of different meanings, but widely as this differ, there runs throughout them all the common idea of regular succession and events governed by rule, which originates in some power, condition, or agency upon which the succession depends. When we speak of law of the land or state, we do not use the term in any of the sense. Since lawyers' conception of law is different, we use the term special and strict sense. Holland, in one of his books, Elements of Jurisprudence, define law as general rule of external human action enforced by sovereign political authority. So basically, law, source of law, is derived not from one person. It is derived from many people and their thoughts and their intellectual thoughts to serve the society can be called as law made for men, is always from men to protect their civilization and civil society. So what is common law? Common law, shipping law are almost same. Common law was originally the law applied by the king of all country through appointed judges. In England, there were called the kings of council, and common law is known as the word of the king. These judges used to decide the cases according to legal principles laid down by the king, and historically, these sources form basis of modern English law and Indian law too, because we have adapted a lot of things from this particular English law. The royal court, which was established in London considered of the learned judges and came out to be as king's bench. The judges were also commissioned by the king to travel around the country to hear cases, and each region was having its own circuit, and judges heading the circuits came out to be as circuit judges. Now, common law is name given is customary law, that is customs and usage of recognized and enforced by common law courts. The Court of Exchanger, the Court of Common Places, and the Royal Court, the Court of King's Bench were common law courts which grew out of the cuirassiers over a period of time. Norman construct in 1066. So this is where basically the common law derived from, where the kings had his own set of judges and they used to visit villages and used to hear the cases and solve the problem. The customs and usage were evolved, recognized by adopted a rule of conduct by English community, also acquired by the name of common law. The same become common for a wide area when found in judicial preferments. They become principle of law. The growth of common law, which began with the centralization of the courts of England, become fixed by end of the region in Henry III. When Henry III was there, it became a centralized way. The judicial system became a little centralized one. The English common law is unwritten and not confined by parliament. If you see, they have an unwritten constitution. Now in India, it is a written constitution. It's the highest. India has a written constitution, but in England, it is unwritten. So the parliament will decide whatever the law is passed. As such, they can be derived fully from law reports. Now let's see precedent and case law. It can be seen that the development of common law had depended upon legal decisions and pronounced by justice. The basic premises of common law existing principles. While passing the judgment, similar should be taken as hello. Can you hear me? Am I audible? No, I think it's lost the net. Okay, I think I can continue and continuing it. Yeah. And the maximum that the judges should stand by what has been decided or the state decides. This is the basis of judicial precedent, whereby previous decisions are binding upon the present case. Now, legislation of statute of law. So, new law is enacted by the parliament in the form known as Acts of Parliament. The statutes may be enacted to clarify or to update existing common law. So, whenever there is some new law being adopted, they called it as Act of Parliament. So, the parliament had all rights to add up new laws. The panel used to discuss and add up the new laws. See, for example, in a time charter, there are a lot of type of charter business. When you take a charter from a ship owner, so there is something called time charter. One may encounter the word charterer shall pay for all port charges, pilotages, stowages, agencies, those who are particular words, and all the usual charges in general words. In such case, a charge for dock dues, for example, would clearly be constructed as same genus, but a bill or a member of the crew going to doctor would certainly know. So when this contract is there in a time period, charterer cannot pay or not supposed to pay charges of a member who is sick. So that that doesn't come under this. Under time charter agreement, it would not come. So the statute law is given effect by court of law, which interpret and explain the law, saying that in the course of interpretation, the justice system will come and explain that what is the actual interpretation of the law which was written. It becomes very clear that doctrine of state or to stand by the past decisions is the name given to rule. Subordinate courts must follow the same. Significantly, like how in India, if you see the Supreme Court order, if there is something, similarly the subordinate courts also can use that as a reference and give a judgment. Same way, they used to follow the same procedure those days. Now, equity. Equity is the law of fairness. From the Latin word, which is equitas, which means revealing. Its purpose is to deal with the situations not prescribed for by rigidity common law system. Today, all civil courts are empowered to administer both common law and equity. What are type of courts? The courts are forms before which any relief is sought by aggrieved. Depends upon the relationship between the aggrieved and the wrongdoer. So when there is a case, the relationship involves that of an individual and the state. Then the area of law applicable will be public law. Some aspects of company law and civil law, most of the criminal laws and areas involving administrative construction law aspect falls within purview of public law. Criminal law is prohibit individuals from conducting themselves in such a manner that is harmful to the community as a whole. So criminal law, you can say as some criminal activities when the shipping company is doing, or when there is a movement of vessel, if there is any crimes or the crime is lodged, then it becomes a criminal law. So based on the investigation, crimes are lodged before a police station against the apprehending party, and which after investigation lodged the first information report, which is FIR is filed, and based on that, the state lodges a petition before the magistrate court in the appropriate jurisdiction, and the accused is given a suitable chance of plead in his case, and if he is found guilty, he will be punished. So that is something of criminal activities. When that's where criminal law is being imposed. Civil law is imposed an obligation of parties which regulate, control agreements between individuals under law of contracts. The action which individuals might have taken with effect or cause of harm or damage or under the law of torts. Torts, what is torts? We will come into this topic very soon. When if there is doing any civil wrongs, the ownership of types of property, including real property, is given to somebody else, or namely the name is being transferred without permission. So all these things comes under, or copyright issues, all this comes under civil law. What's the summary of this? So in this unit, we have sought to establish importance of legislation, how important is law, and what is a different type of effective system to control the society, law in a society. We have the evolution of different legislations. How did different legislations form? How did England has its own law? How was the law in Roman culture? And how did the law evolve from mankind of barbaric nature to this educated man? And how is the judiciary system supreme in most of the countries? And finally, we have concluded with the limitation of statutes and time bars. So elaborately different type of courts, how is the judicial system works, what kind of laws, civil laws, criminal laws, and how is it abiding and how does it work, and what is the purpose of this law is being explained in this unit. Next, let's look into law of contracts. So here we will have to majorly look what is law of contract. So we can expect something called defined law of contract. So you should know what is law of contract. Then you will have to explain various type of contract, what kind of contracts are there. Then you will have to explain or discuss different type of torts and liabilities. Explain the role of agent under law and contract. List of laws related to sales of goods. Explain the incoterms. So this is all the subjects which you will have to look at when it comes to law of contracts. So now when we look at law of contracts, before getting into the subject, I would like to highlight some points. So as I explained earlier, there is something called contract, tort, and wealth compensation. So what happens is that when a cargo vessel is being moved or transportation, basically here what happens is that a vessel is being transported or a trade is happening from one point to other point. Correct? So when there is a transportation is taking place from one point to other point, there can be lot of issues. Now, for example, you are transporting one small item, say from you are sending one courier to your loved ones. Okay. Now you are sending a gift for your friend who is in, say, for example, in Bombay. Now you are in Chennai. So you are sending a gift item from Bombay, from Chennai to Bombay. Now, what are the legal aspects involved in it? And what are the stages of transportation? This small parcel. Now you are sending a small parcel from Chennai to Bombay. So you should understand what are the different type of stages this parcel to reach your friend in Mumbai undergoes. Now, if you are sending something which is, say, fragile, say you are sending a glass item, there is a lot of risk involved. So the shipper, whoever is shipping your item from Chennai to Bombay, will take a sign from you. I hope you have observed. They will ask an extra signature from you saying that if the parcel is damaged, the company is not liable of it. I hope most of you have experienced this. This is a very common thing which you can experience in India, especially. So this is like related to this example. So this is actually a contract between you and the shipping company. Say for example, it's a BTTC or any shipping company. So they'll take signature from it. That is like indemnity. So they are not liable if anything goes wrong with this, like gift item, whatever you're sending. Now what happens? Now for you, if you are sending a valuable item, you will take an insurance. Correct? So when you take an insurance, your insurance company will give you a certain norms. Okay, if you are shipping a valuable item, you will have to declare what is declaration you have to give, what is the value of the item, and what is the item inside it. You have to explain things, and insurance company will give you the insurance. Okay, so you now when you are sending a glass metal or glass material, it can break. So while the shipping movement happens, it breaks. You can go and claim insurance. But you can't go and ask the shipping company because he has already given you saying that no, I am not liable of it. You have taken the liability by signing the contract with the courier company. So this are all small things which I am telling because this is exactly the same thing what you can see even in the shipping law. In maritime law also, it is as similar as the same what you see here. So here there is a ship owner, he has its staff. Now a charterer is somebody who wants to use his ship. Now for example, now I am a ship owner. Now you, somebody of A or B, somebody of you wants to use my ship as a charterer ship and you use it for particular time. Now you want to take my ship and use it to travel from one point to other point to carry your goods. Then we get into an agreement. So when we get into an agreement, we get into a contract. What contract do we get into? We get into a contract saying, I am giving my ship to you, and it is your responsibility to use it for this so and so days. You are traveling from so and so country. You are taking so and so things in it. So all this will be in the contract. So why is this contract being done? Tomorrow, if there is, if I being the owner of the ship, I have all rights to ask it back, right? You may be a businessman who is carrying a lot of goods, so that's why you took my ship. Now what happens? Now if I am asking my ship back, how can you give it back? Because you have already entered a contract with me, saying that for 6 months the ship is mine. So the charterer has all rights to hold it back, saying that there is a legal contract being signed between the both. Hope it is clear. Now let's get into the subject. So the contract, tort, and work compensation are all some similar words which you will come in the subject. Now, when we look at contract, I explained you what it is. Now, tort is something which comes and says that the company is not liable of it. It doesn't legally bind the company of doing anything. Okay, so that is something called tort. We will get into the subject soon. Okay, then there is something called Marine Insurance Act. So Insurance Act, as I said, there is one Insurance Act in Marine also. So if there is anything go some, maybe there is a pollution, you can use this. Correct. So there is common law in India, as I said, which have the authority. Now, say if there is a if the ship is entering illegally into India, the High Court of the nearest coastal area can arrest it. Okay, so all these points you will have to note down because these are all important in your future also. So now let's get into overview of contract. So what does a contract mean? It's any agreement. Okay? It's between two people. It's a very common word which you can hear now. There's a rental contract, there is a house contract, there is a business contract, there's a partnership contract. Everywhere there is contract nowadays. Okay. So in business, making a contract with others is a very important process to put into effect their business plans. Okay. The law of contract forms the oldest branch of legislation pertaining to business transactions. The law of contract seeks to regulate the behavior of a person who make contracts so that any disputes that arise between these later may be resolved amicably. So what does it mean? Tomorrow, if there is any problem between, say, it may be two brothers are doing business in partnership. So tomorrow you never know. It's all human beings. One brother would be greedy and say, "No, this business is mine. This profit is mine." Correct. So now this partnership is going to split there. So if how can the other brother allow this brother to take all the profit? He won't, right? Both of them have put equal hard work there. That is why a contract is important. So the contract will help to resolve things amicably. What do you mean amicably? In a very subtle way, without taking any bigger decision or bigger action. It will be in a very subtle way. We can resolve things. In which way? In under judicial supervision. So judicial supervision is important. So the law of war and different kinds of tortious liabilities are most essential part of law to smooth running of a business. The law of agency pertains to business dealing with the important appointment of agents by principles of in connection with the business transaction. The sale of goods is a common transaction of all contracts which are commercial in nature. Transaction in the nature of sale of goods from subject matter of State of Goods Act 1930. Use of Incoterms are very essential for conducting international business. Incoterms are set of international rules laid down by International Chamber of Commerce at Paris. So it is very important to know Incoterms, the State of Goods Act 1930. What is law of contracts? Now, contract we understand. What is law of contracts? The moral theory of contracts originated and developed in English as law of contracts. It is not whole law agreements, nor it is the whole law for obligations. Various propounders of this theory, like say Sir Erikson, Lord Manford, or Lord Tennyson, had expressed their views as thus: that the moral basis of contract is that the promiser, by his promise, created a reasonable explanation that it will be kept. The important ground for moral basis of a contract is the cause of justice. The law of contract is sanction of legal enforcement of such promises. It also guaranteed the fulfillment of reasonable expectations, where a man is under a moral obligation which no court of law and equity can enforce, and promise the honesty of represent of the thing is consideration. The moral obligation is sufficient consideration for a subsequent promise, which should be received for some limits. Hence, it was obtained that the law of contracts is not the whole law agreement, but whole law of obligations. So basically, here you can understand that law of agreement is law of obligation. So it's a promise what you are giving to the other person. It is something which you assure to the other person, saying so and so can be done. So it is basically a law of obligation. Now when the charter is telling okay, when the ship owner is coming into contact, he'll tell okay, you can use this my vessel to operate for 6 months. Yes, you can. So he's giving it. It's like an obligation. So contract is derived from a Latin word called contractum, which means drawn together. Drawn together. Okay. Hence, contract is drawing of two or more minds to form a common intention, giving rise to an agreement. Blackstone says that contract is an agreement upon sufficient consideration to do or not to do a particular thing. Anderson says that the law of contract is that branch of law which determines the circumstance in which a promise shall be legally binding upon on a person making it. These are all the definitions what they are given of contract. So what is invitation to offer? Where a party, without expressing his final willingness or proposes certain terms on which he is willing to negotiate, he does not make an offer. But he only invites the other party to make an offer on those terms. Say, for example, an advertisement in newspaper, house to let, or house for sale, or a tender, or a railway train ticket. These are all examples for it. Okay, here you know invitation to offer, where a party without expressing his final willingness proposes a tender. Okay, now a party is telling there is a house for rent. That's invitation to offer. Okay, a tender. There is a canteen in railway station to be opened. So this is a tender given out. So whoever is interested can come and make an agreement. So whoever is best, we will choose. It's an invitation to offer others to come and get do an agreement with you. Now vessel is telling, okay, I have a ship which can carry so much of ton of cargo, which is brand new, which has so much also engine capacity, which can travel non-stop so many hours. Okay, and he's giving an invitation saying, okay, any charterer who want to use this, my ship registered in Panama is available. So now anybody who wants to use that can go and approach. That's invitation form. Okay. So next is offer and acceptance. Now what happens is the person making an offer has an intention or willingness to have a contract containing legal requirements with the view to obtain the assent of other party. The assent of other party. Now, an offer, when accepted, becomes a promise. When the person to whom the proposal is made signifies his assent thereof, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Now, the acceptance when a communication communicated completely to the contract at the point of the time is called conscious and idiom. Now, acceptance may be made by words or contract, but must be absolute, unconditional, unqualified. So, offer and acceptance is that when a person is making an offer and it is accepted immediately. Okay, and it is then that means now when somebody is coming and saying, okay, I want your house, you are renting it out, then suddenly the house owner is saying, okay, I accept it. Then there is no change in it. So basically, offer is given, acceptance is there. Okay. So what are essentials drawn to this section for validated contracts? So what are things which you need when we make a contract? We need an agreement. Correct. Now when you are going to a new house or rental house, okay, you will have an agreement between you and the house owner. Correct. You may be doing 11 months agreement saying for 11 months I am using so and so things. House owner will say my house has fan, my house has TV, and I'm giving all these things to you. After 11 months, you have to give it back the same way. If you're not giving back, you have to pay so and so amount. So all this are very clearly written in the contract, and an agreement is made. Similarly, a ship is being given to ship owner is giving a charter ship. So the ship owner has written all the things. My ship has so and so engine. My ship has so and so equipments in it. My ship has so and so number of chains in it. My ship has so and so crew in it. All this, maybe if it is a cruise ship, you'll say my ship has license to run a cruise ship. It has license to do gambling in it. So all these things will be mentioned in an. So agreement is a offer proposal to do or not different acts made by one party and same thing accepted by the other party. Now when he's saying all this, the other party also accepts it. So when the both parties accept it, it becomes an agreement. Okay. So in order to know whether there is an agreement at all between two parties at the same, would be enforced subject to other conditions laid down in the section. So you can keep mentioning, adding section accordingly. Necessary to find out whether there is an identity mined or not. For instance, who owns two houses, one in Old Delhi and other in New Delhi, to sell his old Delhi house to B for rupees so and so. Now B accepts the offer, thinking it is in respect to A, Delhi A, okay, New Delhi's house, A's house. Now, agreement between A and B is not enforceable, owing that absence of identity in there. Now, both confused. The A is thinking that he's selling the B house, and B is thinking he's selling the old Delhi's house. So, there's a lot of confusion in this. So, this cannot be an agreement because the agreement is not definite. It is a lot of confusions can create in this agreement, so it cannot be definite agreement. Next is free consent. Nobody can forcefully put you into any agreement. So, in order that agreement may become enforceable by law, the parties should be in agreement of free consent. Agreement, or they should agree upon the same thing in the same sense. Besides their consent, they should also be free from any sort of pressure. Nobody should threaten anybody and say, okay, put sign here. Like how you see in movies, they'll come, the rowdies will come and say, please put sign here, otherwise we'll kill you, the whole building you want to give it to our name. So here there is no free consent. He's signing the agreement under pressure. So all this pressure without any free consent agreements will be null and void. It cannot stand under law. So this kind of presence of anyone with violating the elements of effects, the consent of the parties, and as much as the party whose consent is obtained by unfair means can avoid the contract. So basically, they can avoid the contract. Next is contractual capacity. The parties who enter into an agreement should be legally competent. So, where person should be legally eligible for signing a contract. A person who is 5 year old cannot go and get into contract. Correct? Now he will have no idea what is it. Legally, the person has to attain 18 years of age. Okay. Other thing is that he has to be in a sound mind. Otherwise, it can be disqualified. Now, a person who is not in his sense, a person who is mentally challenged. Okay, so such a person now cannot get into a contract. He can switch his mind very often because he is not in a sound mind. So, such a person, if you are entering a contract with such a person, it is disqualified. Correct? So, you should note all these points, and it is not disqualified from contracting any law to which it is subject. Next is lawful consideration. An agreement to become enforceable should be supported by consideration. Consideration is something in exchange for something. Okay. When a party to an agreement makes a promise, the promise should be furnished valuable consideration for the promise. This consideration is the price for the promise. If an agreement is not supported by the consideration, it becomes not a factor. That is a bare or naked agreement, not enforced by a law. There is no details in it, so it cannot be considered in law. Subject to certain expectations and specified in act. The reason for instance upon consideration by the law is to discourage promise made without realizing the consequence. Now, court of law do not enforce promises on this. For enforceability of an agreement, not merely there should be consideration of promise, but it should also be lawful also. Even though an agreement is supposed to be consideration, if the same is unlawful, the agreement becomes null and void. So lawful consideration is also lawful object. Now what is lawful object? The object or the purpose of an agreement should be lawful. So any unlawful, now you can't say that you are carrying AK-47 in this also and make an agreement. Okay, it's very clear. So unlawful object. No, sorry, lawful object is must. You can't keep say that you are carrying, you are making gambling in your cruise ship without having a proper license. So it becomes lawful object. You are objecting the law. Okay. So similarly, you cannot go harm any person, cause injury to a person or a property, or immoral activities, or oppose to public policies. All these things when you do, that agreement entered should seek account something which is law deems proper. So only then it can be enforceable. Otherwise, it cannot be enforceable. That agreement is again void. You cannot do any such agreement which is not obeying the law. Next is not expressly declared void. So what does this mean? So enforceability of an agreement also depends upon whether it is expressly declared void by the statute itself. In fact, an act itself has expressly declared void certain types of agreements such as those in restraining of marriage, restraint of trade, restraint of legal proceedings, etc. So not expressly declared void. This is also important which we have to note about. Now let's see common doctrines of law. So what are common doctrines of law? Doctrine of Abraham Fide, contracts of utmost good faith. So that is one point of doctrine of law. Next is restitution stops where repayment begins. Doctrine of restitution. What is other doctrine? Doctrine of frustration. Contract with impossible to be performed. Doctrine of privity. Contract binds only the parties to contract. Doctrine of contract freedom. The parties are free to decide the terms and conditions of the contract which bind them. So all these are doctrines of law. There is a common doctrine of law which can be used. Now let's get into classification of contracts. So before getting classification of contract, I think we will take a 5 minutes break and then we will start.
Okay, sir.
Discussing all this while that there is contract, we have to do contracts between two women will be formed. Two people have to get into contract when there is a legal things, when there is business, and when there is any two people involved, we make a contract. So how can this contracts be classified? Okay, there are following ways where we can classify. One is valid contract. Okay, we will discuss in detail what these contracts are, but as of now, please note down what are the contracts. You should know the difference between these contracts, because that will have a lot of weightage in your question paper also when this exam, and it will have. You should know this for your future also. So, this is very important topic. No difference between these contracts. Okay, valid contracts. One is valid. The next one is void contracts. What is void contracts? Next is voidable contracts. Okay, and the other one is unenforceable contracts. Okay, and the last one is illegal contracts. So these are type of contracts which we can classify. Okay. So section 2 of the Act, which is called interpretation clause, besides defining the contract in the clause, also provides the basis of classification of contracts. So that is where this is being given in section 2. On basis of enforceability, contract may be classified as under. Okay. Now let's see the distinction between voidable agreement and voidable. Okay. Void agreement differs from the voidable contract. Following aspect. Now, void agreement is zero. Basically, void agreement is nothing in the eyes of law. Okay. There is no value when you get into a void agreement, because the agreement itself says void. Okay, so in the eyes of law, when you take this agreement to a judicial system, if it is a void agreement, the judicial system will say, the law will say, sorry, we cannot take this agreement at all because this is a void agreement. Okay, that means it has no value. Okay? So incapable of being enforced from a very beginning, it is devoid of all legal effects. A voidable contract, however, is good in substance and hence enforceable like a valid contract until the party entitled to set it aside elects to do so. If he resigns, the contract becomes a void. Although it was valid till then, it had a value until he was willing to keep it. If he loses it, then there is no value for it. It is not the same. Or even if the resident, after lapse of reasonable time, it continues to be enforceable. Okay. Now, when you look at violating element in a void agreement, totally disqualifies it from being enforceable. As I said, the aggrieved party cannot get any relief from the court in the case of voidable contract. However, the important element can be cured by the party who complains lack of free concern on his part. That he can say. Okay, but he cannot expect any other benefit when he is getting into void agreement. What is illegal contract? It is necessary to point out that at very outset that there is nothing like illegal contract and a legal contract. That which a contract is necessarily legal unless it becomes void on account of subsequent illegality, in which case it becomes a void contract. But not, not an illegal contract. It is therefore necessary to call it an illegal or unlawful agreement. This becomes clear when I regard section 23 of the Act. So an illegal agreement is that which is against the law of land. This one line helps you to clear what is illegal. Any agreement which is against the law of the land means the place where you are, and that particular place has a particular law. And anything which is against that law is illegal agreement. An agreement to commit a crime is illegal. An agreement to commit a terrorist activity is illegal. An agreement to commit a fraud is illegal. So all this is against the law of the land. Okay. Similarly, this will now, if you are in Amsterdam, Amsterdam allows you to do marijuana business. Now, if you are in Amsterdam and if you want to do a marijuana business, and if you're having a contract, it is legal there because that law of land accepts to do such business. But similarly, in India, if you want to do a marijuana business, it is illegal here. So you will be behind the bars. The minute that agreement is itself is gone for the bars. So it is an illegal. Okay, so that is why ensure that law of the land is important. So when you travel from area to area, this can differ. Okay, so area to area, the law also differs according to that particular area. Huh? So it can't be constant. It is something which keeps changing. But illegal contract, the definition is same, but you cannot fix it in one particular place because the moment you move from one particular area to another particular area, the law of land also changes. Correct? So similarly, it is quite tricky to understand it in one single definition, but the concept is same. Okay. Although illegal agreements are void, all void agreements need not necessarily be illegal. Okay, there's something catch. Okay, all illegal agreements are void. Okay, but all void agreements need not necessarily be illegal. Okay, as a term, illegal agreements is wider in meaning than void agreement. Okay, so what is unenforceable contract? So when an unenforceable contract is which is valid and enforceable, but for certain technical defects such as say want to move for something or expiry of a period within which enforceable or absence of writing, maybe something is not returned or registration and attestation is not done or insufficient stamp, etc., it becomes unenforceable. So this is all the technicality of the agreement. So when an agreement is made, if there is any particular line missing, okay, now for example, you are saying that you are giving a charterer. Okay, you are giving your particular ship for a charterer to use. We'll go back to the same example because that makes you understand very easily. So when you are taking an agreement such a way, uh, the the ship owner is very clever. He has never mentioned the ship number or the registration number or the ship name, or which is willing to give you on a contract. Now this becomes an absent contract, absence of writing. So he has not written which is the equipment he's supposed to give you. So what happens now? It will be an unforceable contract. Now you cannot go and tell that, okay, see, you have written so and so, you have to give me so and so vehicle. No, because it's not written there. Correct? So this is all technical difference. So you have to be very careful when you're getting the contract and mention so and so things if there is there. So technicality is very important, which is absence of writing is also you have to keep on monitoring whether it is all written properly. Okay, so all this can remain unenforceable contracts. What is quasi contracts? So quasi contracts is that a certain relationship assembling those who created the contract, say called implied or constructive contracts, derived from the Roman law. Okay, quasi is a Roman law, ex contract, it's something like that. Yeah? Certain relations resembling those created by the contract are also called implied or constructive contracts. There are certain obligations where which are not in truth conceptual in the sense of resting on an agreement, but which the law treats as they were there. It is imposed by law and not created by operation of the contract. It is right in persona. Such kind of thing, quasi contracts. So what are quasi contracts? What types of quasi contracts? See, necessaries of supply or reimbursement. Okay, so reimbursement is a quasi type of quasi contract. Now, certain now when you go somewhere and you ask for reimbursement, right? Like travel is reimbursement. That is a quasi contract. That contract is possible. So necessaries of supply. Now, so much equipment is supposed to be supplied. That is quasi. Obligations of parties enjoying benefit of non-graduation act. That is quasi. A responsible finder of goods. Now, who's responsible finder of goods? That also comes under quasi contract. Liability of a person to whom which money is paid or thing is derived, delivered, mistake or under concern. So all these are quasi contracts. Now let's see what is contract of indemnity. So contract of indemnity, a piece of contract. As such as same general principle related to formation, discharge of contract in general are applicable. However, there are some special features in regard to this. Section 124 of the Act defines contract of indemnity as a contract by which one party promises to save the other from loss caused by him by conduct of promiser himself. Now, indemnity. Now, most of you say, for example, now indemnity form. If anybody were flying or anybody used to fly, use a flight service. Okay, there is something called indemnity form. Now, for example, there is somebody who is a very young one who is traveling in a flight, who is say about 5-year-old, 6-year-old, is traveling alone in a one flight from one place to other flight. Okay, the airline will take a indemnity form from the parents. Okay, so this indemnity form says that anything happens to this child, the parents are responsible. So that is a guarantee. So that is called contract of indemnity. Okay. Similarly, here also, according to illustration appended to section, the contract in defining that against the consequence of any proceeding C, A contracts to indemnity B against the consequence of any proceedings which C may take action against B in respect of certain sum of 200 rupees. This is a contract of indemnity. So I can catch you, hold of responsibility. This is also indemnity. Kind of having a control over it is called contract of indemnity. So there's a definition. So that means a contract of indemnity is the contract by which one party promises to save the other from loss caused to him by conduct of promises himself. Section 100. Now, a contract which with the government to return to India from abroad after completing his studies. Okay, Mr. A contracts with the government to return to India from abroad. He's abroad. He's studying there. Now maybe it's after completing studies and serve the government for a fixed period. Okay. Now, if he fails to return to India, this is a contract of indemnity, and he is bound to reimburse the cost. Okay, this is an indemnity. Now, okay, understand. You can catch him responsible because he has promised something and he has not done so. Okay, this is a contract of indemnity. Okay? Now, English law. Now, do you have any doubt on this indemnity? This is one of the important things which will very frequently hear in your future thing also. Any doubts on indemnity? Okay, now let's get into English law. So it is necessary in the context to make that passing reference to English law relating indemnity. And the contract of indemnity is defined from English law. Let's go back. Where did this get from? A promise to save on other harmless from loss cost as a result of a transaction entered into an instance of a promisor. Okay. So here the English law says that a promise to save and other harmless from loss caused as a result of transaction entered into the instance of a promisor. Okay. Hope this is clear. The definition is clear. So this is where it originated. The comparison of this definition with that given in section 124 reveals that English definition is wider in scope, and it makes room for inclusion of promise to indemnity and promise against any loss which may be caused by natural factors beside that caused by a conduct of promiser or the third person. So further, the promise to save may either be expressed or implied under section 124, which refers only to express the promise. Okay. For instance, certain trucks which were in possession of a plaintiff were claimed not only by the defendant but by a third person also. When the defendant demanded delivery, the plaintiff asked for an indemnity bond. The truck were delivered to the defendant even without receiving the indemnity bond. When the plaintiff was sued for conversion of succeeded. The plaintiff turned sued the defendant, and it was held that plaintiff was entitled to recover the loss from the defendant on an implied promise evidenced by the fact that the plaintiff demanded from the defendant. So indemnity before delivering the trucks. So here you can understand that how an indemnity contract can help to get your justice done. So a promiser is promising something to do deliver, and if that is not happening, or if there is some loss, if there is any problem in that, the promiser is supposed to fulfill. That is an indemnity. Next. Although the definition of indemnity according to Indian law is restrictive, the scope is when compared to English definition. Courts of law in India have followed English law only. Most of them are derived from them only. So we are following the same. So the Bombay High Court observed in Ganjan Moreshwar and Moreshwar Madan 1942. So this is the first party. This is the case which he has Ganjan Moreshwar had a and this is the opposite party Moreshwar Madan 1942 versus them. That I have already held that section 124 and 125 Contract Act are not extensive of law indemnity, and that the court here would apply the same equitable principles that the courts in England do. So this is from on this case the Bombay High Court had given the above result. Now let's see, when as I said it's a transport business. It's we are doing a transport thing. So when there is a transport business, there will be a lot of damages which we can expect. Correct? So what are different kind of damages we can do? Now, when I give an example of just sending a courier from Chennai to Bombay, you can expect a lot of damage because it is not an easy process to move one item to other place, right? There's a lot of things involved. Transportation is involved. People carry it. People put it in the warehouse. Then again, it may go on flight. It may go on ship. So it can go through various stages of transportation, various modes of transport. So the damage to happen to the goods is very, very common. Correct? So we should know what are different kind of damages and how do we handle such damage? How do we compensate such damages? How do we escape being an employer? How does the compensation employer has to give, and how does the company handle the damage without damaging his reputation? All this we'll have to look at. Now let's see what are different kind of damage. So there is something called ordinary or general damage. Okay, ordinary or general damage would be, say, the box of the some, maybe the box is slightly cut, but the goose is same. Some slight crack of it. That's all. Special damage is next one. There is called vindictive or extremely damage. Then there is nominal damage. Damage is for loss of reputations. Damage is for inconvenience or discomfort. Okay, so rule of damage. There is a case of Harley versus Paxton. So the compensation of loss or damage caused by breach of contract. Okay, that is in a textbook. Maybe you can read when you are free. So damage is something which we have to look at. Now let's see what is malice. So malice is a Latin word. It's derived from Latin. It means spite or evil intention, or what we say, somebody unlawfully doing something. That is called malice. So somebody has an intention to damage something. That is malice. Now you have a consignment which is being, which is moving from one place to other place. Now you are, as I said, you are sending some precious gift for your loved one from Chennai to Bombay. Now it is, when it is going. Now it is this parcel is in, say, about in Bangalore. Now it has reached Bangalore. So somebody goes there and burns or buries or damages these goods. Okay, your friend who doesn't like you sending this courier goes and hits and damages that particular this thing parcel. That is malice. All malice activities or wrongful intentions can happen during shipping also. Some intentional thing, if there is behavior, which is called malice. So in every malice, there must be some design and a vengeance in acts of wrongdoer. If A burns B's house intentionally, it shows his malice. Okay. In A's act, malice, dissent, and vengeance against B are present, as I explained. So they keep revenge and go and hurt things, and that's malice. So malice can be divided into two kinds. There are malice in law and malice in fact or evil motive. So malice in law is an intentional doing of a wrongful act. So malice in fact is a called evil or evil motive. That's wrong only. But express malice, actual malice, improper motives, etc. Malice in fact is an act which is done with ill will towards an individual. While malice in law is an act done wrongfully without reasonable or probable cause. Malice in fact depends upon motive, while malice in law depends upon knowledge. Okay, malice in fact means will or any vindictive motive against a person, while malice in law means concurrence of mind with the wrongful act done without just cause or excess. Malice in fact is also known as actual malice or express malice, while malice in law known as implied malice. Okay. Next is general defense of law. So what is general defenses of law? General defenses of or jurisdiction of torts are as follows. Okay. Damage suffered by concerned is not cause of action. So if any damage suffered by concerned is not cause of action. Okay. Plaintiff, the wrongdoer, the case which we explained some time back, plaintiff. So now it's commandum. So no man can take advantage of his own wrong. Okay, so that's basically output of it. No man can take advantage of his own wrong. Just because he did wrong, he can't take advantage of it. Okay. Next is that it can be good defense in tort. So it can be a very good defense in term. And next is that an extraordinary circumstance which could not be foreseen and which could not be guarded against storms, earthquakes, violence, corruption. The common thing is called act of God. So when there is an earthquake, all those things happens. So you can't really go and make anybody responsible. Correct? So such things are called as act of God. Say storms, earthquakes, volcanic eruptions. All this are considered to be act of God. So when there is tsunami, a lot of things happen, a lot of ships damages. Whom will you go and put blame it on? So such things are called act of God. Okay. These are all general different thoughts aspects. So other thing is mistakes. Now say for example, ignorance of law cannot be excused now. Now mistake of fact is that good excuse under section 76 to 79 of Indian Penal Code. Now we cannot put mistake as good excuse. You cannot say it was a mistake. I did not know. That is not a good excuse. A necessity. So necessity is gives a privilege as a private right. So where any wrongful acts were done by defendant to save his life or property or under unavoidable circumstances, he can be excused. Say now somebody is coming to your house and hitting you, okay? Or you saw in the road that somebody is attacking a lady, okay? Or a child is being kidnapped. So it is your necessity to save the child. So that time when you are trying to save the child, you may hit the other party who is trying to abduct the child. Okay. So when you are hitting the person, maybe he may die. Okay, for example, if that person is dying, the court can review it and say that it was a circumstance which is unavoidable. So you had to save the child, so that is why you did it. So in such cases, just naming it as necessity, the person who had to do this can be excused. Okay. So the necessity is one. Now nobody can say mistake. I did this mistake because I know about mistake is something. Necessity is one. Okay. It is statutory authority. So my parliament makes certain statutes. So this makes certain rules. So regard for public welfare is the highest law. Okay. So statutory parliament makes it. Yeah. The object of statutes is to give safety and welfare to majority of people. Okay. Now, judicial acts. From the judicial, first class magistrate to the chief justice of Supreme Court, all the judges, magistrates, and other judicial officers who act judicially are protected by judicial. Hope I'm audible now. There was some power failure, so I had to got disconnected. So we were discussing about necessity. So next, after necessity, we discussed the statutory authority and then judicial acts. So judicial acts is where the act provides protection for all the judges, magistrates who are protecting us from giving the judicial decision. When they are giving their, because the Supreme Court, they are the judges who give us the decision, and because they are judges, uh, there are things that people can go harm them because they have to be unbiased. So some people may not like the judgment only. So it doesn't mean that they can go and attack the judge. Correct? So to protect them, the judges, to protect judges, Judiciary Officers Protection Act 1815 India is present. So Judiciary Act is something which you have to look at. Now let's see law of tort and different type of liabilities. So tort. What is tort? So I was telling that something which will come into this thing. We will have to look at it. So where tort is where the party become liable, is liable, but need not to be legally binding. That is tort. Okay. So tort is a non-contractual civil wrong. The term tort has been derived from a Latin word called torta, which means to twist. So crooked conduct, okay, or a wrong, or etc. The tort is a wrong, which means a harm to determined person, whether intentionally or not, being the breach of a duty arising out of personal relation or and which either is contrary or to law, or an omission of specific legal duty, or a violation of an absolute right. It is a civil wrong for which the remedy is that the plaintiff gets unliquified damages. Now, this tortious act is wrongful act resulting in wrong on the parties, and the wrongdoer is called tortfeasor. When there is a contractual relationship between two parties, okay, but however, the liability arises when it can arise under tort, where a person has suffered injury, or either to himself or to his property. It is necessary that he has a legal right to sue the wrongdoer and seek remedy, okay, out of the injury cost, especially when there is no contractual agreement between the injured party and wrongdoer. Then the cause of action arises, and not out of breach of conduct, but out of tort. So tort is like a twist, which need not to be liably legally binding. Okay, so in a condition where, say, tort is liability, that these are two elements or conditions to be present, okay, when the tort is there. The breach of some duty, that is example, defendant must have acted against the law or omitted his legal duty which caused the injury. Okay, now somebody is taking the gun, police is taking gun and shooting somebody. That means he's doing against his duty. So that is a breach of his duty. Okay, now plaintiff must have legal remedy of legal damages from defendant. A breach of some duty, a tort is a breach of some duty between citizens defined under general law, which creates a civil law of action. Now, the duty must be found in common right, not in the strictly personal relation, such of those of, say, husband and wife and parent and child. Okay. Now, it must be a duty assigned by law, not dependent on the will of the parties. There must be some omission of act on the part of defendant enforced by law. The moral or religious duty do not impose tortious liability, or the term tortious means unlawful. Legal damage. Next, legal damage. The second essential element of tort is that the injured or entitled to get legal damage. Okay, this legal damage are unliquidated damage, that is assessed before such harm occurs. Now, damage cannot be ascertained before the tort occurs, and can be ascertained only after the same has occurred. Before happening a damage, we cannot ascertain how much is the damage before the incident occurred. plaintiff and the damage defendant may not know each other and may not know the nature of tort before it is occurrence. It is the cause of breach of some duty, that is wrongful act or wrongful omission by the defendant in the tort. He is liable to pay the legal damage to the plaintiff. In a breach of conduct, the damage are liquefied, that is calculated before its breach and at the time of contract itself, or it can be assessed on the nature of the contract. Okay? So in a tort, the injured, okay, the person who is injured must prove what injury he has got now, or what damage he has got. Now he has to prove it. He sustained from the act or omission of the defendant. There must be an act of omission on the part of defendant. Now the defendant has not violated any rights of the plaintiff. He is not liable to pay compensation. Okay, he's not liable unless if not able to prove. In some thoughts, the plaintiff receives injury, but his legal right is not violated. This is called as in this case. What happens is that plaintiff receives injury, but his legal right is not violated. Okay. In such cases, no damages are payable by the defendant. In some cases, the plaintiff does not face any actual damage, but his legal right is violated. Okay. In such cases, the defendant is liable to pay damage. In assessing the legal damages, the two principles help the court. Okay. The legal injury and ordinary injury. Sign means without. Okay. And means damage. So violation of legal rights without causing any harm, loss or damage to plaintiff. Okay. So it results in an consensual harm to other. Next, there are various type of torts depending upon the situation. Some of them are trespass, okay, nuisance, negligence, so malice we already explained. What is trespassing? Somebody coming into a place where he's not supposed to go. You might have seen the board, trespassers are not allowed. So when somebody is entering into a place or department where he's not supposed to go and do some mischievous things, that is trespass. Nuisance, somebody is doing a nuisance, I'm disturbing somebody from their work, that's nuisance. Defamation, somebody is defamating other persons, defamation. So all this kind of activities come under various terms. Okay. Now let's see what are the law related to sale of goods. So when you go to a shop and buy a stuff, buy some products, there's a sale happening. So when there's a sale, okay, there's a law for it also. You might have heard that there $1 million was sued against a company because they sold expiry date stuffs and all those things. Nestle was had a big problem because Maggie had so many adulterations because they are selling something which is obeying supposed to obey the law, and but if it is not being obeyed, there can be cases taken against them. Okay, so there is a lot of law involved when you sell a good. Okay, now you can't go to a person and go sell guns to them. It is prohibited. It's unlawful. Correct. Similarly, now let's see what are the laws related to sale of goods. So a contract of sale of goods is a contract whereby the seller agrees or transfers or agrees the property in goods to the buyer for a price. Now you are going to shop. You are maybe you like the TV. You are going to buy a TV. Now when you are going to a shop, you are buying a TV, and they will say the TV is costing 50,000 rupees. Now you may go bargaining with them, and you will tell, no, I want this TV for 40,000 rupees. So when you do this bargaining, it is up to seller's decision whether to give you in this at price or not. So ultimately, the seller is willing to give you at 40,000 rupees. Now the seller is agreeing. Okay. Now seller has agreed to transfer his property, the TV, to you on this particular place. Okay. So this is one kind of selling. So this is an agreement between you. Similarly, there may be contract for sale between one park owner and other. The contract of sale may be absolute or conditional, where when the transfers of property and goods is to take place at future date or time, that also can be said. The subject to certain condition thereafter to be fulfilled. The contract is not a sale but only an agreement to sell. Okay, that's important. Contract is not a sale, it's not a sale, but it's just an agreement to sell. Now you're buying a you're now the online thing is famous. All the e-businesses come into India. So now what you go to Flipkart or Amazon, you buy some items. So there, when you buy an item, you are getting into contract with Amazon, saying that okay, now they'll tell you your item will be delivered to you at so and so time, so and so date, okay, in so and so condition, okay. So you agree to it, correct? So that is called of an agreement. So that is a law of sale of goods. So what happens the moment your order is delayed? You can question them. You can ask them. See, you have agreed that you will deliver this at this time, but it has not come. Now you can go question them. So tomorrow they are answerable to you. Correct. So this is a law related to sale of goods. Okay. Similarly, the goods which you receive is in a damaged condition. So you tell them, sir, this is a damaged condition goods. I can't accept it. How you are telling this? Because it is in your agreement. Okay, your sale agreement, Amazon would have given you already, but nobody reads it. But if you go into their website clearly, they would have given an agreement. Any goods sold will not be returned back. It will be there in some shops. They'll say any goods sold will not be returned back. But they'll say no, 7 days we can return back. That's their law related to sale of goods. Okay, it is their choice to keep the law. Okay, their choice to keep the agreement. Now it is up to you to accept it. If you are not willing to accept it, you will not get into it and buy that. If they say that this particular good will not be returned back, say for example you're buying a shoe which will, you are doubtful that whether it will fit your leg size or not. So you will not be willing to get into an agreement to any shop where they say that no return possible. You will go to a shop where they say that okay, you can return back the item within 3 days. Okay, so that is where your choice comes in. So that this is law related sale of goods. Now let's see. Now let's discuss the essential ingredients of a sale. Okay, when there is a sale, what is essentially involved in it? Okay, a bilateral contract. So a person cannot buy his own goods, hence there must be two parties. Okay, there will be two, buyer and a seller. Now a buyer can't make a agreement on his own. Buyer cannot make an agreement saying that okay, I want to keep an agreement. That will never happen. So there is a two-party agreement. There should be two people as a buyer and seller. That's essential. Money or consideration. There must be sufficient consideration, which is called the price. So when a buyer and a seller is there, you should come upon and tell that this is my price. This is the price. Now you want to ship. Now you are the charterer is coming and requesting the ship owner that I want your ship. So the ship owner will say, yes, you can get. I will give you the ship, but you have to pay so money for me for this many months. I want your ship for lease. Charter is buying. So that time he will tell me you have to give so and so money. So he will agree upon it. So you have a buyer, you have a seller, and you have a money also. Okay. Next is sale of contract of work and material. So what is sale of contract of work and material means? Basically here they are trying to say that what kind of work, what kind of material you need. Okay, or you're buying, say if you are customizing something, so you will tell I need so and so material to be used, I need so and so stones to be added in a jewelry. You can customize it. So that's the sale contract. You will tell them clearly what you want. Okay. Goods. Next is goods. It means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to forming part of land which are agreed to be served before sale or under contract of sale. That is goods. So basically, whatever is that, anything, anything which is movable property or actionable claim, the money including stock, share, growing crops, grass, anything can be goods, which are agreed to be served before sale or under the contract of sale. That is goods. Okay. So next is effect. Okay. Now what are the effects of now goods are said to be perish. Effect of perish. What is perish? Did I say any examples of perishable items to you? No, I don't think so. Yeah. So perishable items is something. Say now you are doing a shipping business. Now you are, say for example, you are having a mango estate. Okay, you have it says mango season is coming up. Now there is a lot of demand for this mango in Africa or Europe. Indian mangoes are very highly valuable assets in Australia, Singapore. Now they love Indian mangoes. So now since you are in India and you have to export these mangoes to other countries, you can't go and get into an agreement with the cargo company or shipping company, which will say that it will take 8 months to reach your mangoes to Singapore. So if somebody is telling that, will you go and give your contract to that person? You will not. Why? Because your mangoes can perish. And it maximum can be good in a good state to eat is 3 months. After 3 months, it can perish. It can decay. Nobody can use the mangoes. So you will load every mangoes from your Chennai port, and mangoes are gone. After 8 months, if it is reaching Australia, you think anybody in Australia can use the mangoes? Nobody can. Correct. So these are all called perishable items: mango, fruits, flowers. So what happens when you have a perishable item? Your first motive is that to send it as fast as possible to the opposite side in a very safe manner. The minute there is something lagged, your product is damaged, then your whole point of doing business is gone. So, for example, when there was a Suez Canal blockage, now recently, if you have read the news, there was tons of ships in line, and imagine how many perishable items would be there inside. All would have been damaged. Now they're all going to claim insurance that okay, my goods are damaged, my business is gone for loss, so on and so forth. So you should know what is effect of perish. So goods are said to perish when they are physically or commercially cease to exist. The effect of perishing of goods, which form subject matter of contract of sale, are laid down in section 7 and 8 of Act. Goods perishing act at before the contract is made. According to section of the Act, where there is a contract for a sale of specific goods, the contract is void if the goods without the knowledge of seller have at the time when the contract was made perished or become so damaged as no longer to answer to their prescription in the contract. So if you're sending the goods which is already perished, okay, you can't put the blame on this the company. Okay, so you have to be very transparent. According to the section where the subject matter of sale happens to be specific goods, the existence of the same is essential for validity of the contract. As if the goods have at or make before making the contract there is or become so damaged that they cannot any longer answer to their description in the contract. Okay, and seller is not aware of the same, the contract becomes void and the buyer can get back the price of goods. Okay? That is something when you are doing selling perishable item, you should be confident. Now let's see what is import terms. Import terms are said to be international rules published by the international chamber. Okay, so in international chamber has published these import terms. So marine insurance and all comes under INCOTERM. So INCOTERMs are related to an international classification that has been put in place to harmonize international trade because 70% of the earth is covered with water. So 70% of this water area is used for transportation. So imagine there are so many countries in the world who has this 70% water with their land boundaries in it. Correct? So, Incoterms will be a common thing, which when the vessel is transporting its item from one point to other, they all agree in this common term. Most of the countries accept this are the common terms. Okay, that is what Incoterms is. Now, say they allow to codify duties, rights, responsibilities of importers and exporters for say loading the goods, the types of transport, the delivery, the risk, insurance, the formalities of transportation or the documentation, everything will be in a common thing. So every place when the ship goes or vessel goes, they cannot go and keep changing the insurance, the formalities. It's very difficult. So they'll have a standard form to follow. So Incoterms in layman normal language is that means who will pay the freight, okay, and the insurance charge. The buyer and supplier in this case, this is done to split to three critical vertical of a shipment, which are task, cost, and risk. Okay. Now, above mentioned the factors are associated with the transportation and delivery of goods between buyer and seller. So now let's refer to below mentioned diagram. Say now before I proceed, now we should say source. Now what is source? Now when the from the source the item is going, okay, your consignment is going from the source. Then what happens? It has to clear the customs, custom clearance system. Then it will go into the port or air cargo terminal. The cargo terminal will go, okay, after clearing customs, and from there it will take the flight or it will take the ocean route, okay. Then again from there it will go back to the cargo terminal of the destination. Then again it will do a cargo clearance, custom clearance. Then it will go back to the receiver. So that is the usual cycle of the shipment. So Incoterm means which are supplier driven for exports of the shipment. Okay. So these are the following stages which they have to follow when this happens. Now DDU or DAP. This means that duty will be paid by buyer. Okay. The shipment will be door to door. Okay. So basically, the buyer is paying the duty. So this kind of shipment, what happens? You are sending something from here, from your door. It will be transported to that particular opposite person's house door that will reach. If it is duty is not paid, what happens is that the property which is being sent will be in customs hold, and the customs holder, the opposite party has to pay the customs duty. Then only he will have to release or take the consignment. Most of you would have heard somebody sent an Apple iPhone from the US to India and all this. But if he has not paid Indian custom duty there, he has not paid the duty, what happens is you are his friend, you are somebody who is waiting to receive iPhone. The cargo company will call you and tell, sir, you have to come and pay the customs duty, which is say so and so amount. Otherwise, you will not get the phone. Okay, so this is something which you have to look at. So, so supplier is responsible to get deliveries to buyer's warehouse. Insurance is paid. Now, what happens if the phone is damaged? Insurance also has to be paid. Okay. CAF. This means that shipment will be delivered till port. CSMA will be delivered till port of buyer's country. But this is most commonly used in quota for export shipment, as the supplier do not have to worry about the customs. Now it's buyer's headache. Now buyers will know he'll go to customs and he'll get it clear. Insurance is again paid by supplier. Okay. The term used by buyers for import shipments are EXW, okay, or X work. This means that the buyer is responsible for the door-to-door delivery for imports you want. This starts from picking up the shipment from warehouse of supplier to getting it customed, cleared in other country and their own. It is most commonly used in import shipments. Okay, and now in the diagram, there's a diagram which is on about it's FOB. Now FOB, what is mean by FOB? This means that the buyer is responsible to pick the shipment from suppliers or to cargo. Okay, the supplier makes sure that the shipment is just ready to collect it. Okay, and port customs clearance. Now the supplier pays for the shipment of cost, dropping the cost till terminal and getting the custom clearance in the country. The buyer is responsible once the shipment is at port and cargo terminal at his own warehouse. So what happens is that they will wait for some time until sometimes there is nobody who is claiming the item, then it will go on auction. Okay. So if you now see, this is import auction 2010. What happens here? You see import terms, as I said, X workplace. Now warehouse service, you can see the obligation and charges. You can see now who is paying it. Now seller, if you see X workplace warehouse service, seller is paying it. Whose obligation? Now free carrier place. Now seller is obligation. Now free onboard port, seller is obligation. Cost and freight port charges, seller is paying it. Okay. So you see in this chart, most of the things seller itself is taking care of. Okay. Now, in loading at a point, if you see, the buyer is paying it, X workplace. Okay. Other than that, everything the seller itself is taking care of. Okay. This is the whole circle of how the goods is going. So if you can see from the diagram only, from the warehouse, this consumer is collected, it has been put in the ship. From the ship, it has gone freight prepared. Then it has reached the other destination. From there, it has been moved to the final destination. Okay. If you can see the seller and buyer relationship, this can change. This can change. This import term can change. Okay. This is the other one. This is another one. So where you can see that the Incoterm works, how it works. So here, if you see the obligations of export packing, seller is taken care of. Okay. At one point, if you see from down above that, if you see the, if you look at unloading at destination, buyer is paying it. Again, buyer is paying at free carrier place, account transfer. Alongside ship, buyer is paying it. Then again on board vessel, buyer is paying. So most of the items buyer is paying. So obligations match. Okay. So these are all inco docs is what we say. Inco term. Okay. So this keeps changing. You can find more details on this also. So, in this unit, the importance of law of contract for smooth running of business, okay, has been highlighted. So overall, we'll come back now. So law of contract is made for smooth running of business. Okay, ultimate aim of law of contract, you should know that is contract is made. The law of contract is made because your business has to run smoothly. Okay, tomorrow when you are doing a business, there should be nobody should come and obstruct you from doing it. Okay, so that is the law of contract. So in this unit, it has given us an idea of okay, how this law is done, what is the use of this law, and what are different kind of torts, liabilities, various dimension of it, the role of law, the agencies of international business. It's also discussed, and we have also learned legislation pertaining to the sale of goods. How do we sell goods? What are the law which has to be occurred when we sell goods, and who are the parties involved in selling goods? And we also explained Incoterms, what is the use of Incoterms and what is the benefits of it for seller and buyer, how smoothly it helps in functioning it in International Chamber of Commerce, and where it occur. All these things we have been studying in this unit, and I hope this is clear. If you have any doubt, you can reach me. Okay. So next we can go to unit 3. So I think before going to unit 3, do we need to take small break? Can we take 5 minutes break before we get into unit 3? Anybody? Okay, let's take a 5 minutes break and we will rejoin the class at exactly 4:15. We will rejoin at 4:15. Okay,
Okay, sir.
get into the unit 3. So law pertaining to carriage of goods by sea. So this is something which is very important, which you have to look at, because it's something which is very related to your career also in future. Okay. So far we understood how is the good sale, what is the goods law used to when you do a normal good sale. And all this. Huh? So now we will get into the law which is used for carriage of goods by sea. Okay. There's so many type of transportation: sea, air, road. Okay. So road will have its own law, air will have its own law. So what is the law which is used when something is being transported in sea? Okay. So this is something also known as shipping law. Okay. Or trade, when there is a trade. Okay. There is something called multi-modal act, multi-modal transport act 1993. Okay. That's something which you will have to study in detail. You can note this law also. Multi-modal Transport Act 1993 is something which is important, which we'll have to keep an eye on it. Then COXA, which we already said, Carriage of Goods Act by Sea, Carriage of Goods by Sea Act 1925. That is something important. Okay, so now let's get into it. So here what happens is list various laws relating to carriage of goods by sea, then explaining the international convention on the carrier's liability and its limitation. Okay, discuss how rules is there pretending to carriage of goods by sea. What does how the rule says on this transportation is all we'll cover in this topic. Now, in general, because since you're all in this, I would like to share something. Now, see, now if a baby is born on a ship, okay, and on ship is being moved. Now, when a baby is born in a ship, which country, now it is moving in international waters, okay. Now a baby is born in the ship. Now which country would that baby belong to? You can unmute and answer me if you have this knowledge. If you have answers, you can please unmute and answer.
Is
Anybody?
that as per the port region?
The ship is the vessel is in the international waters, okay. The vessel is in the international waters and a baby is born there. Now which country will the baby goes to? Which will be the passport of the baby?
I think it's on the departure country.
Okay, you feel it is of departure country. Okay, any other suggestions? What do you think the baby belongs to which country? Because if you are flying also, it can be very similar to this. That's right. Which any other comments, answers you would feel to share?
Or if
Sir,
the
can
vessel
you?
registers in which vessel in which
Sorry.
country? A vessel's registry country.
Okay, that is also there. Okay, any other answers? Any other suggestions or any other thoughts? You think the baby is born in international water now, is traveling. Which country would the baby belong?
After born, or which country it is going to call? Next country which is
The
going
calling
to call.
country with the destination it's supposed to go. Huh?
Yes.
Okay. Nice. Any interesting answers? Anything else you would feel? Imagine you in the situation. You are a sailor tomorrow. Your wife is on board. You are a father now. So which country would the baby go to? Okay, I had interesting answers from you. Now let's get back to this. So what happens? You are right. Most of you were right only. So what happens is that, so when a baby is born in international waters, it can either take a passport of or country of origin of the nearby country which it is passing to. Okay, provided the country has that law. Now, say for example, if it is in US, US is a welcoming country, and if you are say about 300 kilometers in that contingent zone, if that ship is near that zone, US will be welcome to take that baby as US citizen. Okay, but there are some other countries which doesn't give. Okay, and other countries, some countries also say that the origin of the ship, now the ship manufacturing, and now ship which is the registration of the ship is originated from which country, that country the baby belongs to. Okay, that is also chance of doing that. So baby can, so if you look at that way, if the baby is getting the ship oriented, 70% of the ships are all from Panama, because the tax is low there. Okay, the taxation, everything is low, and population is also low there. That's why most of the ships are registered in Panama. So the baby can go there and baby will get that citizenship. Yeah, that's one thing. Now, similarly, if it is a diplomat who is traveling, and if the diplomat is getting becoming a father, and the diplomat is the baby is born, that means then diplomat have to carry his own country's passport. The baby will be again given the same origin of country. The diplomat's passport, which country is the same country, the baby also allowed to be. This is only for the diplomatic passport holders. Okay, the others we will go get into this category. Okay, so now let's get into this subject now. So, a contract of carriage of goods by sea is called a contract of affreightment. Okay, and the consideration of carriage is called as a freight. Okay, this is important. Please note it down. Okay, a contract of affreightment may take the form of a charter party, where an entire ship is hired. I was telling about a charter, no? A charter. So the charter is a person who hires the ship for his purpose. Okay, or a bill of landing, where the goods are to be carried in general ship, which can be used for purpose by any person. In both these contracts, the ship owner undertakes the responsibility of carrying the goods of a consignor safely and securely to the destination. Okay. Next is law of carriage by goods by sea. So is the body of a law that governs, okay, the rights and duties of shippers, carriers, and the consignors of a marine cargo. Primarily, the concerned with the cargo claims. This body of law is an aspect of international commercial law and maritime law. The law obligations of carrier by sea to shipper of cargo are to provide seaworthy ship. So, what do you mean by seaworthy shipper? We spoke about this seaworthiness certificate. So it is the obligation, it is the duty of the carrier or the owner of the ship to give a working, a proper conditioned ship. That he should tell that this ship is in a proper condition, which can take so much of load and can travel so much of distance without any problem. Okay, that is called seaworthy ship. That is called seaworthy. This has to be seaworthiness certificate has to be provided by the carrier or the to the shipper. Okay. Now, to issue a bill of lading, this also has to be issued. Now, to properly and carefully load, handle, or store, carry, keep, care, and discourage the goods carried, okay? To proceed the reasonable dispatch and to follow the agreed route. Okay? So all these are coming under law of carriage of goods in the sea. All this will be responsibility of the consignee or the shipper to be fulfilled. Okay. Now let's see the cargo claims. So what is this concerned cargo claims? Now, consignees or indeed any lawful holder of bill lading who wishes to make a cargo claim, okay, because their goods are substandard or have been lost or damaged in the sea at the sea, typically have four options now. It's the persons after goods is missing or something, they may sue the seller or the shipper. Okay, they may sue the seller, the shipper, or the carrier. Okay, it's their choice, or they may claim for their own insurance policy. That insurance policy will come under Maritime Insurance Act. That was Maritime Insurance Act 1963. So that is coming under that point. Okay. Next, a suit will lie against the seller if the seller has insufficient title, or the goods are not satisfactory in quantity, or do not comply with the sample or description. When you get a wrong thing, you order for Apple iPhone and you get Apple, normal Apple, then what? You can go sue the company. Okay? It doesn't match your description, correct? So that is something that you have to look at. These are all cargo claims. Now, a suit can lie against the shipper if the goods are damaged or insufficiently packed, or any loss suffered to the insufficient labeling. All these things you can file. They'll put Samsung phone cover and give you Apple iPhone. You will not accept it because you ordered for Samsung. Why is Apple doing that? So that is insufficient. Labeling is wrong. Okay. Now, suit will lie against the carrier if the damage occurred abroad, aboard ship. Okay, if the damage occurred aboard ship, the carrier's fee and the club cover normally bear the cost. Okay. Now, if the cargo is damaged, whereas the shipper without fault, example of the goods have been properly packed and stored, or if the carrier is either blameless or exempted from liability because of act of God. Okay. Now suddenly some tsunami or some wave came in, the ship moved off, and some vessels fell down in the ship. Okay. Now whom do you blame? Now we cannot blame the shipper on it because it was not a deliberate attempt. It was act of God. Okay. So the cargo owner will have to claim on his own cargo policy. A claim have been paid. An assured right of claim will be subordinated to the insurer, who may consider proceeding against the party who has caused the damage. A ship owner may sue the time charterer or OI charterer in the event of breach of contract. For instance, if the charterer exceeds the late time, or if he exceeds the time which was agreed, then he will have to pay the demurrage, will be paid. Okay. If the charterer cannot comply with notice of readiness, that is called NOR, the ship owner may have to cancel the contract of carriage and claim the damages for any losses which is occurred. These are cargo claims. Okay. Now we have to look at other things. So the act of Brussels, which says that to all contracts of carriage evidenced by bills of lading and involving outward shipment from ports in United Kingdom and Northern Ireland, it defines a contract of carriage as those contracts which are covered by a bill of lading or other small similar document of title, in so as such a document relates to the carriage of goods by sea. So including any bill of lading or any similar document as a aforesaid issued under the pursuant to a charter party from the moment at which such a bill of lading or similar document of title regulates the relations between the carrier and the holder of the same. Okay, so by the definition, also a carrier includes the owner of the charterer who enters into a contract of carriage with the shipper. Okay, the carrier includes the owner of the charter who enters, the owner of the charter who is entering into the contract with the shipper. Okay, where the goods indulge all goods and merchandise with the exception of live animals and cargo stated in the contract as carried on deck, and in fact so carried. Now, carriers of deck cargo are left free to contract on what terms they wish and normally exempt themselves from liability for loss or damage, or howsoever cost. Okay. So now the contract of carriage of goods by sea is called a contract of affreightment, which we already discussed. Okay. Now the contract of affreightment may either be form of a charter or a bill trading, which is expressively contains the terms and conditions which is set in the contract of affreightment. Now this contract is done between this both. Okay. Now what happens is that implied undertaking every contract of affreightment, whether it will be form of a bill or lading of a charter party, there are certain undertakings on the part of carrier which are implied their seaworthiness, reasonable and dispatch and no deviation. This we already explained in the chapter what is seaworthiness and all. So that's all. Now let's see there were so many cases which was in the court, which we can see there was held in various judicial discussions in English courts, namely Elder Damster and Co. Limited versus Patterson and Zochinus and Co. Limited 1924, and there is John Carter Limited versus Henderson College Ellis Limited. It is all settled that the ship owner who contracts to carry the goods by sea warranties not only with the ship in which the cargo is carried is seaworthy, okay, but also be light, staunch, strong, and reasonably fit to encounter whatever ends that may be expected on a voyage. So same includes experiment used carriage during the cargo. Okay, he is not only responsible for seaworthiness, but also whatever he encounters during his travel, he has to be responsible. Okay, that is the outcome of that judgment. So as I said, the law of carriage goods by sea is governed by provision of carriage of goods sea act POGSA, that is 1925. Article 3 rule 1 of the act provides the ship owner is bound, he is responsible before end on at the beginning of voyage to exercise due diligence to make the ship seaworthy. It is his responsibility to keep the fitness of ship. The ship has to be seaworthy. Okay, that is his responsibility according to POGSA rule article 3 rule 1 1925. Now the seaworthiness also includes the cargo worthiness. Okay, it's not just the ship, but the seaworthiness means the obligation to provide a ship fit both for a particular voyage and for a particular cargo. In British India Steamship Navigation Company 1915 to KB 774, lemons were loaded for carriage to London. Okay, this ship was sailed via Mombasa. Mombasa is a place in Africa. This is via Mombasa, which was a plague contaminated port those days. Okay, due to this, in affecting the process of mandatory or indemnity French port, the lemons arrived at a destination is damaged condition. Okay, The ship owner was held liable for the loss of having violated implied warranty. A ship is not seaworthy if it is not fitted with loading and unloading equipments, and if its crew is incompetent of in or inexperienced. So I give an example of mangoes. Okay, from you are sending from here to Australia, and if it doesn't reach there on time, okay, similar case is this, where the ship owner is being sued, okay, because he could not transport the lemons from point A to point B. Okay, so this is there is not only the sea worthiness but also the cargo responsibilities on the ship. Okay, now let's look at the Hodge rules. Okay. So House rules of 1924, formally the International Convention for the Unification of Certain Laws. And basically, it's a unification. Basically, it's a convention, international convention to impose minimum standards upon commercial carriers of goods. Basically, okay. Here, what happens is it's uniformly accepted by many countries, so that their working becomes much easier. Okay. Carrier's responsibility as per future law is that make the holds ready to load cargo and preserve and discharge the cargo. It's a responsibility. Properly man and equipment and supply of the ship is responsible. Make the ship seaworthiness, that is his responsibility. Issue the bill of lading after the loading, that is his responsibility. Carefully load and handle, store, carry, keep care, and discharge of the cargo. It's all his responsibility. It all comes under Hodge article or Hodge rules. Okay. Now, the Hodge rules on business and human rights. This can be used in other points. Now, judicial mechanism, if you look at the Hodge rules, the transparency and open justice is something which we can see. That is highlighted there. Now, third party intervention can be seen in judicial mechanism. Similarly, litigation and funding can be used. Okay. The same way, Hodge rules can be used in non-judicial mechanism where emphasizing on human rights complaints, voluntary process, human rights expertise can be non-judicial mechanism. International arbitration, if the prior information informed the concern, the parties decide the arbitral process or enforceability under the New York Convention is all Hodge rules on business and human rights. This can be considered as Hodge rules. Next, developments of rules related to contract of carriage. So, how does this kind of carriage develop? Now, Hodge rules. Okay, there is Hodge rule. There is something called a Hamburg rules also, which is in your syllabus. Okay, now Hodge rules was developed by CMI and still being used mostly. Okay, it was in 1924 they started developing it in CMI, and they started implementing it. And Hodge rule was still being used in 1968. At 1992, the Hamburg rule started. That was developed by UN CTAD. The most latest, not used widely because people are still used to Hodge rules. Okay? Now, then what happened in 2009 is that the Rotterdam rules came in, which was developed by UTCTA, and but it is not yet enforced. It is still in the hold, but still discussions are going on how to use it. So let's discuss on Hamburg. Now, Hodge rules we discussed. Now let's see what is Hamburg rules. So on beginning, a contracting state, any state which is the party to Hodge rules, okay, in their original or amended form, shall apply and enter into force in respect of that state. The provision of a convention and applicable to all contracts of carriage by sea between two different states. If the port of loading, port of discharge, port of optional ports of discharge provided in the contract is contracting state. The bill of lading or other document evidence the contract is issued by a contracting state or legislation of the state governing the contract. Okay. Now, Hamburg rule says that the Hamburg rule says that the contract on the Hodge rules in the original amended form shall apply and enter into force in respect of that state. So whenever you are entering one particular area, that rules will be applied. Okay. The provisions of convention are applicable to all contracts. This provision, when you enter into a particular state or region, this provision of convention is applicable to all the contracts of carriage by sea between two different states. Okay. If the port of loading port of discharge and port of optional ports of discharge provided in the contract is a contracting state. A bill of lading or other document evidence of the contract is issued by contracting state or legislation state by governing the contract. Okay, so this is something important. You'll get a question asking say difference between Hamburg and house rules, which we'll have to look at it. Next is see in this unit now we have learned the carriage of goods by sea, what are the laws we use it, what kind of rules we follow, which includes different form of contracts, carriage, and what is the affreightment, lay time, what is demurrage. Demurrage is damage cost. If there is a damage in the payment done against the damage, demurrage. Further, we have learned various international conventions and other carriers liability. We have also listed hose rules and the law of carriage by goods, rules. In final part of this unit, we have discussed about the rules governing the liability of multimodal transport operators. Okay, these are the laws which we have to look at. Apart from this, now as I said, 70% of the world is covered, Earth is covered with ocean. So a ship can go anywhere. Correct. So this 12 nautical mile from any border of the country is called as a territory water. Now this territory water is basically belong to that particular country to do whatever they want. Okay. Now after 12 miles, 12 nautical miles, then comes your contiguous zone. Okay. So this contiguous zone, what happens is that is under your customs control. There taxation happens, immigration can question there, and politically that will be the boundary of any country. Okay. After that, then you have EEZ, something called EEZ. EEZ is EZ, what happens is this economic zone, exclusive economic zone is like say 200 nautical miles from the border, land border. So in this 200 nautical miles, 200 nautical miles should be say roughly 350 to 370 kilometers from the land border. So this area fishing happens. Okay, now if there is oil drilling that belongs to that particular country, which if it is 370 kilometers away, that range. So if it is in that range, this now there is a border which is shared, which is closer to 370. Okay, if there is two countries which has border only at 150 kilometers of difference, then they take a neutral level. Okay, in Kodam, as per the rule, they take a middle line, whatever is the equal distance, that place that considered as a border. Okay, the 370 kilometers that area, the fishing and all happens. They can go fishing. Now what happens because of this only, most of the times the other countries will come and capture our fishermen because they do not know where exactly is boundary. So there can be some confusion. But this is exclusive economic zone because that zone is economically benefited to country. So we call it exclusive economic zone. That is 200 nautical miles from any country to dimension. Okay, that is something which I wanted to share you. Next is international water that we know. International water is where after this economic zone, the next is called international water. Now, if you look at this South China Sea and all, there will be a lot of confusion because China will say that is my portion, then there comes Taiwan, then there comes Australia. There's a lot of countries which is in between this South China Sea fighting for their places, you know. So this ship, whichever is crossing there, has to undergo so many countries and the rules. So to make all this easy, the international laws are being used. That is commonly adopted. So that is why the smooth sailing of ship is being given. Okay. So that is all I can highlight. Now, other thing is that now we can look at what are unauthorized entry. Now, sailing on one's nation's water without the permission. So this happens. This is unauthorized entry. So what happens when you are unauthorized entry? The nearest court can give a warning or can go and ask them arrest the vessel, whichever country. Recently, I think in 10 years back, a US ship came into India. It was in international area, and they had some arms or something like that. So suddenly the High Court gave a thing to arrest the vessel. Okay, so that unless unauthorized entry with illegal items can be stopped. Smuggling or of exotic plants like marijuana and all those things are illegal. Smuggling of the thing is punishable. That also is illegal thing. Illegal carrying of weapons. Okay. Now illegal fishing. Now I say that exclusive economic zone is a particular. So once you cross that and go to the other country's border and do fishing, it's an offense. If the other people come this year also, it's an offensive thing. So exploiting the deep sea resources is also one of the crime. That is also one part of crime. So maritime crime, there will be a lot of hijacking, pirates would be there. That is also in the international waters. That is something crime also which can be seen. Drug trafficking, human trafficking, and especially discharge in the ocean waters. Now all the garbage and sewage. You can any ship cannot come from other country and come into our zone or our country zone and discharge this thing. These are all offensive things. Tax evasion. Now, if particular document is not there, they do not pay a tax to enter this particular area, then that is also some crime. These are all the common types of crime which you can see in this business. So all these things are lawfully incorrect. So I think for today we have done with the 3 units. If you have any doubts, you can text me or you can reach me also. So basically, we have covered this now with the law in point of mind, because this is a slightly complicated subject, because we are not going to be lawyers here. But you should know what is the law points and what is the law which is right to do, which is not right to do, and when you are saying what is right, what is wrong, and what are your rights, what is the rights of being a shipper, what is the complications when you do something wrong, and what is the shipper's duties, what is the cargo hold duties, what is the customs duties, who will question you, and what kind of laws and where did this law come from. So all these things will be covered in this unit, this session. And if you have any doubts, you can reach us anytime. uh, I think by this I'm concluding the session. Anybody have any doubts to ask? Madam, I am concluding the session then.
Okay, sir, it's done.
Yeah, I've just completed the 3 units now, and I would, if anybody wants to, anybody have doubt, you can reach me. You can reach my contact on the madam if you need it. I can guide you some reference books on this regard also, which will help you. If you need such this thing, you can reach me then. Yeah.
Sure, sir.
Yeah.
Oh, no. Yeah. Thank you, and stay safe. Stay safe.
Yeah.
Yeah. Okay.
You too.
Okay. Thank you. Thank you very much.